Since the first time of European contact in Canada, dating back to the 1500s, the Aboriginals of Canada have been profoundly affected by these unwelcomed relations and the laws that came to be imposed on them due to such, one in particular being the Indian Act. Let us first go back to the first 300 years, during the 15th to 1800s. The Aboriginals were a people of their own cultures and traditions, which ranged from nomadic lifestyles such as the Plains peoples who followed the buffalo to settled farmers such as the Iroquois. The arrival of the white man would eventually change everything and fundamentally affect the Aboriginal people's relationship with the land and its resources. Aboriginals did not have centralized formal governments in the European sense. Aboriginal societies were largely governed by unwritten customs and codes of conduct. They had treaties with each other long before European fur traders or settlers arrived in what is now called Canada. Aboriginal nations would use oral treaties to settle land disputes and end other conflicts, including war. Trade and marriage arrangements were commonly made between tribes as well.
When the Europeans arrived, they brought with them their own methods, especially the written treaty. Particularly after the conquest, when the British gradually began to establish a stronghold on the continent, Aboriginals were not always happy with the outcomes for these written treaties. The governments of the time sometimes did not include oral promises made to the Aboriginals in the written treaty. This forms the basis of many land claims today, as Aboriginal leaders demand to be given what they are promised. Moving forward to 1867 was the initiation of the Indian Act, which officially made all Aboriginals legal wards of the state. This act was introduced and implemented by the federal government in order to amend and consolidate previous laws concerning the Aboriginals, such as the Numbered Treaty. The act listed in its conditions for being considered an Indian according to the views of the law. For instance, any woman that married an Aboriginal man could be considered an Indian and could be allowed to live and even be buried on a reserve. These women also received other cultural and social benefits by gaining Indian status. However, any Aboriginal woman who married a white European male was now considered to be a bona fide member of the Canadian society. She lost her Indian status and every right that came with it, as well as all half-breed Indians were not entitled to Indian status, particularly pertaining to the Métis.
Aboriginal women's rights in terms of equality in Canada, whether that is on or off reserve as well as on the job site. We also must note that the use of the word band, as understood in the Indian Act by the Government of Canada, is reference to a body of Indians for whose use and benefit are in common, particularly in terms of lands. Euro-Canadian women were considered legal non-persons until 1930, but by the end of the 1800s they had acquired the right to vote, to enter into contracts, and to own property, including land. By contrast, Indian women under the Indian Act were considered legal non-persons and did not have the right to vote or enter into contracts until 1951. Therefore, women were defined as Indians if their fathers were Indians or if they married Indians, but were not defined as Indians if their mothers were Indians. However, many, if not most, Aboriginal societies were matrilineal and defined lineages through the mother, not the father. In many Aboriginal societies, women were chiefs. In Iroquois culture, for example, clan mothers selected and deposed chiefs, and men and women had equal rights to participate in major decisions, such as those concerning land surrenders.
Under Section 12 of the changes made in 1951 to the Indian Act, a woman who married a non-Indian was not entitled to be registered and thus lost her status. Section 12 also removed status from a woman whose mother and paternal grandmother had not been status Indians before their marriages. These women could be registered, but they lost their Indian status as soon as they turned 21. Indian men, however, did not lose their status when they married non-Indian women. Between 1958 and 1968 alone, more than 100,000 women and children lost their Indian status as a result of these provisions. Looking at some Aboriginal activists that have engaged in legal battles to regain the status lost by women as a result of Section 12 of the Indian Act, Mary Two Axe Early, Jeanette Lavelle, Yvonne Bedard, and Sandra Lovelace are some of those who challenged Section 12 of the Indian Act through court cases, political appeals and lobbying, and in Ms. Lovelace's case, an appeal to the United Nations. The 1960 Canadian Bill of Rights proclaimed that all Canadians had an equal right to not be discriminated against on the basis of race or sex, among other things, and were entitled to the protection of the law. Despite this, the Canadian courts ruled that Section 12 of the Indian Act did not discriminate against Indian women.
Bill C-31, an act to amend the Indian Act, was passed on June 17, 1985. Section 6 allowed for women who had lost Indian status because they married out and their children to apply for reinstatement. However, the grandchildren of a woman who married out are not eligible for reinstatement, although the grandchildren of men who are married out are. As well, Section 6 excludes children of 2 successive generations of Indian and non-Indian parents from registration. Since Bill C-31 was passed, there have been close to 250,000 requests for registration. 114,512 people had gained Indian status based on Bill C-31 amendments, while 44,199 applicants had been denied. Overall, Bill C-31 has restored Indian status to roughly 118,000 Indians. Because so many Indian women lost their status, most of them, including many of those who have regained status, live off-reserve. Off-reserve Indians have fewer rights than on-reserve Indians. Off-reserve band members have only partial tax exemptions and may not be exempt. Off-reserve are entitled to federal program benefits is unclear. The rights of non-status Indian women living on reserve are also limited. Since they are not band members, they do not have a right to vote, do not enjoy treaty benefits, and do not have tax exemptions. This bill was introduced as an amendment to the Indian Act.
They don't talk territory. I talk territory. This is my territory. I can go anywhere in my territory and make my living.
The inherent rights of self-government is a part of Section 35 under the Constitution now.
A look at your newspaper or at your TV will confirm that women today are becoming more and more active in the politics of this country. Our First Nations women are no different. In fact, a separate voice of Aboriginal women has emerged with new clarity over the last few years, a clarity that speaks strongly about traditional values and Native self-government.
Many Aboriginal women lost their Indian status when they married a non-status man. Yet at the same time, the Indian Act determined that a Caucasian woman would gain status when she married a status Indian man. This discrimination lasted until 1985 when Bill C-31 was passed. At that time, some women and their children were reinstated as status Indians. Since 1985, the rebuilding processes of Aboriginal women within their communities has slowly taken hold. Yet, there is still a long way to go.
Hi there, come on in.
Lily Yellowhorn?
Okay, great. Sorry, that's Lily Yellowhorn?
Yes, Yellowhorn.
Wonderful.
Yes.
So I'm your legal advisor. Care for some water?
Thank you. Yes.
So what will what's your concern for this evening?
I've come here today to seek your legal advice due to some difficulties I'm having on the reserve. So I thought that things were changing and I was protected under the Human Rights Act, under the Canadian Human Rights Act, but I'm finding that things aren't so, and I'm just wondering what my rights are as an Aboriginal woman.
Right. Well, in this specific situation, while Section 3 of the Canadian Human Rights Act does prohibit discrimination on the basis of race, sex, and marital status, of course, among other things, Section 67 of the Act makes the Human Rights Act inapplicable to any provision of the Indian Act or any provision made or pursuant to that Act, I'm afraid.
So who then has authority over this?
Well, that's a good question. The actual matter at hand for that is, the application of the Canadian Human Rights Act turns on whether the Indian Act explicitly provides authority to the Band Council or the Department of Indian Affairs to undertake the action complained of.
I see. All right. Well,
Yeah.
I'll make sure to bring this information back to the other women on the reserve. Another question I have is in terms of domestic issues. If I choose to leave the reserve in order to save myself from further abuse, what rights do I have?
Well, you know, the Aboriginal Indian Affairs Department, the Department of Indian Affairs, is Indian women, such as yourself, face many problems as a result of Canadian laws. And because lands on reserve fall exclusively within federal jurisdiction, provincial laws concerning matrimonial property do not apply. So a court, therefore, cannot decide who has the right to live in a house on reserve as under the Indian Act. Only a band council can do so. So, I mean, the court can, however, have an order, and the husband can compensate for the wife for her share of the property, but you would only have partial share, I'm afraid.
All right, well,
So,
thank you for filling me in with this information.
I really wish there was more I could do, but unfortunately, it's just the way it is.
So maybe I can come and speak to you again, and we can talk about possibly going to court and furthering what rights I have here. So
Absolutely.
hopefully there's change for this.
Thank you so much for coming in here today and educating yourself further.
So many women, especially Aboriginal, are discriminated against, abused, and forced through so many inequalities. This presentation is basically to show you where they come from, the progress that has been made, but still how much farther they need to go to fight for change. Aboriginal women are more likely to face domestic abuse than any other woman in Canada. While 1 in 10 women are abused by their partner, almost 1 in 3 Aboriginal women are abused. If an Aboriginal woman leaves the reserve to escape domestic abuse, she can lose her home. There are long waiting lists for housing on reserve, and often a great deal of pressure on band councils to reallocate housing as soon as possible. Many Aboriginal women who wish to live on reserve cannot do so because of a lack of housing.